Item number 22, my lord.
Item
22, my lord. My lord, I am appearing on behalf of my lord PJ Sir. My lord, Meta, my passport for
22 at the request of made on behalf of Mr. P.J. Soike. Passed over for a week. Yes.
My lord, I want to beg to mention for listed motion tomorrow, my lord. Transfer
Unlisted
petition. No, tomorrow, my lord.
listed motion. What is that?
No, tomorrow motion, my lord. This is a transfer matter, my lord.
Ah.
Otherwise, my lord,
You have filed it.
I'm filing it, my lord.
You file it.
I'll file it, my lord. But within 10 minutes, it will be filed, my lord.
Transfer matter.
To transfer, my lord.
That
Same
would be
department,
bench 3 matters.
my lord.
That would be in the bench 3.
Bench 3.
It's a bench 3 matter. I'm not taking up bench 3.
Huh?
Huh? As a Howard matter. We are giving you permission, but check up. I think it is.
Honorable Justice Suman Sham is there, my lord. But I cannot mention there, my lord.
That can be a reason. You'll have to.
Because I have to mention here.
All right. All right. For tomorrow.
Tomorrow.
Lordship, item number 28, yesterday we have filed an affidavit in opposition. Kindly call for a record.
What is the point? If you filed it tomorrow, we will have to see it.
Lordship,
Yesterday.
Lordship, call for a record, sir.
It is not there in the file today.
Lordship.
So let it be listed on some other day along with the affidavit.
Lordship, petitioner may not.
Huh?
Petitioner.
Why did you file it yesterday?
Lordship, actually, there was for vetting some.
Whatever it is, so you have filed it yesterday. We can't be expected to go through your affidavit like that. We'll keep it on some other day. Who's for the petitioner?
Please, October, Lordship.
Will we wait for the matter to be called up?
Lordship.
May I please, Lordship, my lord, I beg to mention for listing in hearing, my lord.
Listing hearing is not possible. We'll list it for orders. Give it.
My lord.
Give it for orders. We'll fix it. Yes.
I beg to mention for listing admission matter on next week.
Not next week. Matter of which year?
23.
23 will come in January.
Challenging the punishment order.
Let it be. January can. Let it be on
29th.
8th of January. 8th of January. Yes.
May I please, Lord? I beg to mention item number 25, pass over for the day.
Item 25 passed over for the day.
Lordship,
At the request of Mr.
R.L. Chutia.
R.J. Chutia.
R.L. Chutia.
R.L. Chutia. Yes.
Your Lordship, I beg to mention two petitions for listing, Your Lordship. These are
For what?
matters. Lordship, for orders. No affidavit has been filed by the respondent.
All right. Okay. Get a date in December. 18 December.
Okay.
Please, Your Lordship, I beg to mention item number 21 matters. My lord, in this matter, my lord, the conducting counsel, Mr. S. Bhattakur, is out of town, but prefer some accommodation.
Mention is made on behalf of Mr. S. Bhattakur that he is out of station. At the request of the council, matter stands adjourned for 1 week.
Right, ma'am.
Yes, Mr. Chutia.
My lord, in this matter, we are supposed to file an affidavit, my lord. An additional affidavit. But instruction we have not received yet, my lord. So we have sent two communications, my lord. My lord will grant us last chance, my lord, and indicate that, my lord, if the instruction is not forthcoming, my lord, the district commissioner has to, my lord, have a personal appearance before this court, my lord. My lord, it's not forthcoming. We have written two letters, my lord. My lord will just give us a last chance.
That order has already been passed, my lord.
Hmm?
That order has already been passed. If they are not filing the affidavit, it will be presumed that the.
We have filed an affidavit. Additional information the court will take.
But that is the order, my lord. Last order, my lord. order
What
dated
is
6
the, what
10
is the issue? What is
2023.
the issue here?
My lord, in this particular case, my lord, this honorable court passed a specific direction to appoint the petitioner, my lord, as the persons below the petitioners were appointed. And that order was passed by the by this honorable court, which is at page 35, my lord.
Page 35.
Right. And it starts from 36, my lord. Also, when look into the, my lord, who passed, order pass was on that date, my lord, in 2009 itself.
Hmm.
Page
So,
36,
30.
judgment order, date of hearing 24/2/2009. That order was passed.
What was the direction of the court?
That is in the, my lord, page 43. On paragraph 9, my lord. The above facts leaves the court satisfied that the petitioner has not been treated fairly and the situation therefore has to be remedied. This court is informed by so-and-so learned counsel for the petitioner that even though the petitioner has been released by the order dated so-and-so, he is working on a casual basis, on a fixed pay. The court has also been informed that in the meantime, the respondent has retired from service on so-and-so. The aforesaid circumstances, if correct, would indicate that the petitioner has put in over 10 years of continuous service as on date. The court is therefore inclined to take the view that the present would be one of the rare cases where the court should direct for suitable appointment for the petitioner in any grade 4 post. That is a specific direction of this court in 2009, my lord.
Grade 4
And-
post is, please continue.
In any of the establishment under the deputy commissioner, Dorong, subject to the condition that the persons below the petitioner in the merit list had been given regular appointment. And it is the admitted position, my lord, that the persons who are below the petitioner has been appointed, my lord. And those orders is reflected, my lord, in the order dated, my lord, Two 2023. That factual part has already been elaborated in that order, my lord. And page 50 is the admitted position. That is the principal secretary to the government of Assam, so and so. Page 50, last para, my lord, last fifth line. Page 50. He has submitted a report with the list of selected persons, has stated that 8 selected persons below the petitioner in the select list were appointed. Page 50.
Yes.
And it is the admitted position that the persons below the petitioner has been appointed and the direction passed in 2009, so the appointment is required to be made. But the petitioner was appointed in Panchayat and Rural Development, and thereafter he was removed from that post, my lord. He was appointed by the deputy commissioner. The stand of the government is that he was appointed in the Panchayat and Rural Development Department, and the deputy commissioner does not have the right to appoint there. So he was taken back from the Panchayat and Rural Development Department, and subsequently he died, and the pension benefit has not been paid. Scale of pay has not been paid. So the husband of the petitioner, my lord, petitioner filed this case, my lord. And specific direction has already been stated in all the orders elaborated by this court. That is on 23/1/2023, also 02/01/2023, and chance was given to them, my lord, to take the instruction, my lord. But that is not,
No, after this, what happened? After this page 50?
my lord. They have not appointed the, they have not removed the, taken back the petitioner from the service, my lord. That Panchayat
but
and Rural Development
In the
Department
meantime, he expired.
expired, ma'am.
Now, what is your prayer here?
Here, my lord, to pay the pensioner benefits, arrear salary.
Any contempt was filed against non-compliance of the earlier order?
It is in 2009, my lord, that order was passed. So the repetition was filed in, my lord,
2018.
2018, my lord. Thereafter, another earlier also repetition was filed.
No, 2000, after that balance is 2018 only. No contempt was filed.
Yes. You can convert this into contempt. Willful deliberate violation of an order of the court.
Then my lord will pick the date whether this is my lord maintainable after a lapse of this this many years, my lord.
We are converting it into a contempt proceedings for willful and deliberate violation. It is between us and the contemptor.
My lord, contempt of act, my lord, will come into act within 1 year. Has to
No.
be, my lord.
Article
Continuous
212 also
violation.
there.
My lord,
It's a continuous violation.
not continuous violation.
Of course,
my lord.
when
2009
right, there's a direction.
My lord, 2000.
These arguments you can,
delay and laches,
these
my lord, 2009.
arguments you reserve in the appellate forum.
The petitioner comes, my lord, before this court, my lord.
No, is it the fault of the petitioner that he has to come before the court with a contempt? Does it require a contempt for implementation when the direction is passed against the department in the presence of departmental councils? Is that what you are submitting? That an order passed by the court is required to be executed only if you file a contempt.
My lord,
Is that your submission?
no, my lord, that
Then-
is not my submission. My submission is only that, my lord, I said the petitioner did not come before this court with the contempt.
Exactly.
came
That is the fault of the petitioner. Now
After-
you explain your conduct, why you have not applied, why you have not complied with this order.
That is what, my lord, I said that instruction is has not reached me as of now.
Who is supposed to give you that instruction?
My lord, the deputy commissioner, my lord.
Deputy Commissioner where?
Dharan, my lord.
Shall we call him along with the records?
My lord, I prayed for a last chance that I will file an affidavit.
We don't need your affidavit. We want your instructions. You get your instructions. Get the instructions why this order was not complied in spite of this order.
But that is
Then now you can't comply it.
that is
Can you comply this order now? This man is already dead.
my lord. That part, my lord, we have already filed an affidavit, my lord.
Where is that affidavit? What does it say?
My lord, affidavit filed to the Assistant Commissioner Dharan.
Hmm.
For Resolution 1 and
Setting.
in Para 4, my lord, I'm reading, my lord. That with regard to statement made in Para the files of the petition, the deponent assisted that the Director Panchayat and Rural Development Assam by Lord of Sachin Sir, because the Deputy Commissioner Dharan to ensure the status of the petitioner has been and prolonged and but it was not that Deputy Commissioner Dharan did not respond to the associate letter and did not took any step as the Director Panchayat Rural Development Assam was requested to consider the appointment of the petitioner's husband and to make the payment of his monthly salary since his joining by letter number 13 from 11/8/99. It also true that the petitioner husband was released from the post of peon by Block Development Officer Sachin Sir as per direction which is from the Director Panchayat and Rural Development. Area salary was paid as per the Honorable Guwahati High Court order in petition number 13 Sir. Area salary was paid to the petitioner husband from joining 36/3 by the Block Development Officer. That with regard to the statement made in the petition Assam, but then it is allowed to continue the service of the petitioner husband at Dalgaon Development Court. Assam is complying with order of the Honorable High Court, and the petitioner then could not appoint the petitioner husband due to non-ability of sufficient number of vacant posts in the amalgamated establishment of the
So
Mongol.
now what instructions do you want?
Lordship will look into, my lord, paragraph 11 of the affidavit, my lord, or paragraph 11, page 4 of the affidavit. It is, and further begs to state that the petitioner's husband was appointed in compliance with the Honorable High Court's order as he was selected candidate. Due to non-availability of sufficient number of vacant posts in
You are
amalgamated-
reading from paragraph?
paragraph 11, my lord, page 4 of the affidavit filed by the respondent number 3,
That is the additional deputy,
Assistant Commissioner, my lord,
assistant commissioner.
paragraph 11.
Yes.
It is admitted position. It is a further begs to second line, further begs to state that the petitioner's husband was appointed in compliance with the Honorable High Court's order as he was the selected candidate. Due to non-availability of sufficient number of vacant posts in the amalgamated establishment of Deputy Commissioner Dorong, Mongoldoi, it was not possible to accommodate all the selected candidates. Therefore, petitioner's husband was sponsored to Block Development Officer Dalgaon, Salmari Development Block in compliance with Honorable High Court's order. It is not on the fault of the husband of the petitioner that he was not appointed in the office of the establishment of Deputy Commissioner and he was appointed in the Panchayat and Block Development Officer, my lord. So the as per my lord, so his continuance of service is established, my lord, and he died subsequently, my lord. And
My
due to
lord-
my lord, let me complete.
Yes.
And my lord, as he died during the my lord that period, my lord, so he has the right accumulate accrued to the wife of the petitioner, my lord, and for that purpose, wife filed the petition, my lord.
It is not that, my
Yet,
lord, that
I have no objection if he
That
can take a
this
last
is
chance
not-
to take the instruction and
if he did
submit
not
it.
comply, my lord. If he tried and he was accommodated in, my lord, in the block, since there was no position, it is not that the deputy commissioner didn't comply with the honorable court order, man. That is there.
No, then what happened? Why was he not accommodated in the block? What happened to his services in the block BDO office?
13, my lord, again, I'm reading paragraph 13, which is there. That with regard to statement made in paragraph, the petitioner husband was paid since his joining from 36 to 3, and he was released from the government service by BDO of Dolgao, block, as per the direction of the director of Panchayat on 4/12/2003. On the other hand, as reported by the BDO, the executive officer Dolgao Panchayat Barang by this letter number 13 from 12/6/18 that the petitioner husband said Akbar Ali was allowed to work temporarily as per the resolution of Dolgao Panchayat. Yeah. And in the meeting held.
Now, in this context, what instructions are you awaiting?
My lord, my instruction, my lord, we are just trying to find out, my lord, whether that 8 persons below him were appointed or not, my lord. Only that part, my
That
lord.
report is already there.
My lord.
Page 50.
And my lord,
Assuming you find out
my lord.
that they were appointed, now what would be your stand?
Page 50.
What is the government going to do?
But-
What is the department going to do?
But the thing is that, my lord, we have already complied, my lord. We have, if we could not accommodate him here, we have given him an appointment in Panchayat and Rural Development, but that was the deputy commissioner, my lord. Thereafter, my lord, Panchayat will under, my lord.
Where is
reply
that
to, my
order?
lord,
Where is that order of the BDO and the director of Panchayat and Rural Development, para 13?
that, my lord, that order copy I don't have as of now, my lord. I'll speak for it.
Hmm?
That order copy, my lord.
Hmm.
For my friend, he is there, Panchayat. There will be more.
Yes, Panchayat. Page number 66. Continuous paging 66, para 13 of the affidavit.
I don't have a copy. I don't have a copy.
I am not asking you whether you have a copy. We want to know whether your office has a copy and we want to see it.
Okay.
So you need to get copies of these two orders. Kindly take note, para 13. Order of, as per the direction issued by the director PNRD 4/12/2013 and 12/6/2018.
And 12.
Mr. Dhor, you wanted some time for what?
I even don't know there is how lot of matters that if there was any vacancy even ballot, any curable ballot thing, because he has to be, and now I find that ballot already he was appointed. It is not that
See, the difficulty is that there is an order of the court. The government chose it fit not to go for a review, not to go for an appeal. Now, once there is an order of the court, and if it is an order which was required to be complied with,
We have complied, my lord.
how?
My lord, we have appointed him.
No,
Doing
kindly, no, kindly see the direction in the order, of the order. To be appointed under the establishment of the DC. If the DC could not do it, this order ought to have been modified. Page 43, para 9. Page 43, para 9.
Yes, ma'am, that is what I'm saying. The court is therefore inclined to take the view that at present would be one of the rare cases where the court would direct for suitable appointment of the petitioner grade 4 post. In
Any
of
grade
the
4,
acts of
any
petition
grade 4
under
post.
Petitioner Dharan, subject to the condition that person below the petitioner in the merit list had been regular appointed.
So the only precondition is people below him should not have been appointed. In that case, this order would not apply. There is a report where it says that, where is the report, Mr.
Case 27, Lordship, look in the repetition. Deputy Commissioner himself admitted that the 8 person below the petitioners were appointed.
27.
Page 27 and page 50, and the report of the Principal Secretary also, my lord. Page 27,
Yes,
with
and
reference to the above.
where is the report?
With reference to the above, I have the honor to inform that as per the record available, 8 selected persons have been appointed in this office whose names were listed in the select list below the name of the petitioner. And page 50 also, my lord. And page 50 is the letter of the Principal Secretary to the Government of Assam. Last 4 lines, my lord. He has submitted a report with the list of selected persons and has stated that 8 selected persons below in the petitioner in the select list were appointed. As such, the judgment of this honorable court, my lord, that I should be deemed to be appointed in the post, my lord, that is continuous, that is in continuance. And so the husband of the petitioner is entitled to the arrear salary, and the petitioner is for the pension and other benefits. This is the case. It is the admitted position, my lord, that below the persons were appointed, my lord.
Yes, councils, we want to see the order. When can you get it? Don't ask for time just like that. This is a 2018 matter and you are in the face of contempt. You have to satisfy the court why we should not proceed in contempt against your officers. Mr. Dhor, kindly understand the gravity of the matter. Matter is deferred, enabling the learned councils to obtain the specific instructions as to why the order of the court passed earlier, why the order dated. What is the earlier order?
25/6/2009.
Sorry.
(24/2/2009). Page 36. 26/2/2009.
Has not. List again. After a week. 7 December. 7 December.
My lord, pay revision matter.
Hmm?
Pay revision matter, ma'am. In this party board, my lord, they've been denied 2009.
Yes.
This is So they've been denied, my lord, pay revision of 2017, my lord. Prior to that, my lord, 2010, the pay revision was affected. But 2007 is denied, which they have put some rider, my lord, which, my lord, to us is illegal. And,
Pleadings complete.
my lord,
Pleadings are complete.
readings are complete, my
So we'll admit, listed for hearing.
lord. Short date,
Short date, sometime in February.
It will need a hearing.
Yes, admit pleadings are completed. Matter is admitted for hearing. List in the next hearing list.
Next hearing, my lord. Or January, my lord.
Yeah, next hearing list.
Next
It's not in the next hearing list. You can make a mention for upgrading and we can take up the matter.
My lord.
Yes,
In the earlier occasion, my lord, this honorable court, the respondent number 26.
affidavit filed.
Lordship, DPC department, your lordship, extra copy has not served. Your lordship. And your lordship, I would like to draw your attention on page number 26, your lordship, that is an extra.
First tell us there is an order on 4/1/23
Yes, your lordship.
for filing an affidavit. By whom? By whom?
Extra copy has not served upon us, your lordship.
Respondent number 2, my lord, government.
Respondent to pension department. One affidavit is here.
My lord.
It is here. Tell us. Tell us. Tell us.
Paper copy did. Copy did.
Almost covered case, my lord, Sanjita Roy. Yes, my lord. Sanjita Roy already covered, my lord.
Where is the order?
Order, my lord, kindly check case 31, my lord.
31.
Case 31. That order.
Yes.
It's more page 26 to recognize it.
And operative court on page 38, my lord. Paragraph 30. By their judgment of order, my lord, declared that 6 years of deduction service, my lord, is arbitrary, my lord.
No, no.
It appears to be reasonable, not reasonable. And therefore, my lord, after calculated the entire service, the petitioner serving 25 years, 1 month. Therefore, eligible for pension, my lord.
25 years
25
after deduction.
My lord.
Then he's eligible.
Without deduction, my lord.
Huh?
Without deduction, my lord. 25 years.
Even if you are even if it is deducted, then
Then 19 years, my lord.
19.
19 years.
And second part, my lord, the petitioner overstayed in service, my lord, 9 months, my lord, and that part recovered, my lord, from the leave salary encashment. Finally, see, my lord, annex page 22, my lord. Page 22, my lord. 2,36,500 deducted from the, my lord, leave salary encashment. It is not
Already deducted.
already deducted from the leave salary. As per, my lord, the apex court judgment, Profik Masi, my lord. Grade 3 and grade 4, my lord. After retirement, deduction is impermissible.
But already deducted.
Deducted, my lord. Therefore, my lord, direct to repay that amount, my lord.
You show us Rafiq Mashi.
My lord.
Misrepresentation.
And what is the order of this court at page 42?
42, my lord. Page 42, matlab, and in similar circumstances, matlab, this honorable court directed to give pension from the date of judgment, my lord.
Now what is your grievance here? Only for recovery?
Recovery and as well as pension, my lord. Already terminated case already paid, my lord, stating that the petitioner has not completed 20 years of
20
service, my lord.
years. That is, your
After
lordship,
deduction 6 lakh,
page 26
27.
and 26, your lordships, annexure 6, your lordship.
Kindly
Oh,
peruse
deeper,
paragraph
deeper.
18 of that judgment, my lord.
His total qualifying service after deduction of initial 6 years of MR period comes to only 19 years 1 month. As per Assam Service Pension Rule, that is 1969, a temporary government servant who retired with less than 20 years of service is not entitled any pensionary benefits to be paid. Only terminal gratuity at the rate of half-month pay for each completed year of service, provided he has completed not less than 5 years continuous service, unless service is made confirmed. It is clearly stated, Your Lordship.
Where?
Page 26, Annexure 6, Your Lordship. Third line, Your Lordship. Third line onwards, Your Lordship.
What is page 26?
Annexure 6,
Uh,
Your Lordship.
Do you agree or disagree with the judgments?
Lordship, so far as pension part is concerned, Lordship, that may be without I mean, deduction
Covered.
of initial 6 years will not be applicable,
Hmm.
Lordship, as far as Sanjita Rai judgment, Lordship.
Hmm.
Only issue remains here, Lordship, that recovery part, Lordship.
That is Rafiq Mashi?
Yeah, no, Rafiq Machi will be there, but Lordship, on last date, Lordship, I prayed for some time for obtaining instruction, Lordship. That instruction is awaited now. So, Lordship,
What instructions are necessary?
I mean,
You have already recovered.
yes, but that overstay was due to his misrepresentation, or it was because of the ignorance or fault of the department?
Obviously, because of the mistake on the part of the employer. Merely because he represented employer is not going to release him.
If I obtain that instruction, Lord, it will be satisfaction to us also.
Kindly peruse the page 24, my lord. It is the pension forwarding. It is stated below portion. In this connection, I would like to inform you that the date of birth of the Sovereign Bottomata as per his school certificate as well record. Accordingly, his date of retirement is on 31/1/2017. But the executive insurance contract has been released him from service as on 31/10/2017 instead of 31/1/2017. Executive insurance released Malak on 31/10/2017.
Yes. Is there anything in the pleadings now to say that you have already filed your affidavit?
If it is not only pension department.
Pension.
Pension. Lordship, we will not take much time, Lordship. I am praying for just 3 weeks time now. Provisional pension part.
3 weeks to give us what instructions?
No, that part only, Lordship.
No. Where is the question of misrepresentation? You examine this matter and pass an order within a particular time frame.
90. Intimation document. Lordship. One. That is
You
one
examine
rule
this
is-
issue because you are going to ultimately go through your records to find out whether any misrepresentation was done. So you do that exercise, and once you are done, you refund the salary. What is the point in keeping it pending?
No, Lordship, definitely it will be decided against him, Lordship, and he will again have to come to this court. Lordship, one rule is also there. Here, the mistake of the department, only mistake, Lordship. Probably prior to the retirement, Lordship, it was not intimated to him. And Rule 95 says, Lordship, even if it is not intimated, Lordship, it becomes his responsibility to convey the department that his date of retirement falls on such as such date, Lordship. That was not done by the petitioner also, Lord.
You have not filed your affidavit. You filed your
Lordship,
affidavit.
Lordship, we will file, Lordship. Lordship will grant me 3 weeks time, Lord.
Not 3 weeks. Not 3 weeks. We'll give you 10 days time to file your affidavit. Matter is otherwise covered.
So
Except
pension
for your
fund is
instructions. You
Yes.
have to now interpret that in view of whatever facts
No,
you
Rafiq
propose.
Masi, so far as overstay is concerned, Lordship, Rafiq Masi is not directly applicable. Lordship.
That is what you have to urge.
That Purushottam Pandey, other judgments are there, not Rafiq Masi. Rafiq Masi only in case of
Grade
other
4. Grade 4 employees.
Yeah, grade 4 is there, but
Hmm.
so far as overstay is concerned, Lordship, Rafiq Masi is not directly applicable, Lordship.
No. The Rafiq Mashi is the law. You show me any judgment where it has been altered or differed with.
No, there are, so in case of overstay, Lordship, other judgments are there.
Other judgments on the facts
No, Lordship,
of
yes,
those
Lordship.
cases, because this is the case where in cases of grade 3, grade 4, you are not
recovery.
supposed to recover.
Yes, that part will Lordship will definitely consider, Lordship, that Rafiq Masi is concerned, grade 4,
Uh,
Lordship will consider,
uh,
but other judgments will also come into play, Lordship. Other Purushottam Lal Pandey is there, Jagadishwar Pandey is there.
hmm.
Our judgment is there, Ramjitan is there.
Those have not overruled Rafiq Mashi. Those have not watered down Rafiq Mashi.
No, that is what I am submitting, Lordship. So far as payment of overpayment is concerned, Rafiq Masi is directly applicable. Rafiq Masi is applicable only in case of overpayment, Lordship.
That's right.
Not overstay, Lordship. This is a case of overstay, Lordship.
Overstay were
Wrong fixation, Lordship. Wrong fixation over Rafiq Masi, Lord. But overstay, other judgments are there.
there is no wrong fixation. It's a
Here,
question
Lordship, wrong fixation is not there, Lordship. It is overstay, Lordship.
No,
Lordship,
even
only that
in
much
Rafiq
instruction,
Mashi,
Lordship.
there is no question of wrong fixation.
This is overstay, Lord. And in Rafiq Masi also, your Lordship will file in paragraph 2 and 3, Lordship. That word misrepresentation is also there. I mean, dear Lordship, in paragraph 2, 3, and 4, Lordship will file that specific statement that the principles laid down in judgment will be applicable only if it is not on the, because of the misrepresentation of the person concerned. So that much instruction only I want to have, Lord. Whether the petitioner had any role in his.
You have already taken a stand that this is not a case of wrongful payment, it's a case of overstay.
Yes, Lordship. That's why.
So therefore, Rafiq Mashi is not applicable. That is your stand.
No,
What further?
no, Lordship. Here, Lordship, the chief engineers later clarified that the concerned executive engineer allowed him to stay beyond his superannuation date, Lordship. That much instruction only. Look, why he allowed, Lord. That much only, Lord. Nothing else.
Why he allowed? How are we concerned? He stayed. Why he allowed? What instructions? How these instructions are going to alter the claim? Whatever reason the executive engineer may have, he had allowed him to stay.
Lordship will take note all the facts. I'm not praying for much.
After 10 days, the request of Mr. P. Nayak, Learned Standing Council Finance,
PTC, Lord.
PTC, to complete his, enabling him to complete his instructions and obtain required, file necessary affidavit. It
Lord,
is submitted
affidavit may
by
not
Mr.
require,
P.
Lord.
Nayak that the case projected by the petitioner is not a case merely of recovery of excess amount, but a case of overstay. And therefore, the principles enunciated in case of Rafiq Mashi will not be applicable. He craves leave to address the court on this issue. Mr. Patkiri, learned counsel for the petitioner, however, disputes the submissions made by the petition, by the respondents. Let it be listed after 10 days. Give a date after 10 days.
Our presence will be recorded. I for one.
Will you please record the counsel. 13, not 13, 12 December.
Lord.
Mr. Bora, Mr. Upaidhyay, and Mr. Hassan appears for the respective.
I reform D Bora for respond number 2.
D. Bora for respondent 2, Mr. Upaidhyay for
1 in 3.
1 in 3, and Mr. Hassan for
Number 4.
respondent 4. All right. So 3 and 4 are together.
Malak, the
Issue is similar.
regarding pension, my lord, but not similar, my lord.
Okay.
In so far as Sanjita are concerned, my lord, it is covered.
Huh?
Sanjita, I mean, it is covered.
What is the other issue?
No other issue.
No other issue. Yes, who's appearing for 4?
Pension. Pension and public affairs, department, treasury.
This is only for pension.
Pension, my lord. Without deduction, my lord.
Yes.
Lordship, I have just received my instruction, Your Lordship. We have resubmitted the pension case to the Accountant General on 9/10/2023, along with the required documents, Your Lordship.
So we'll close it in terms of the judgment of the coordinate bench. Coordinate bench says the minus 6 years, and then given that minus 6 years is not required.
Yes, sir.
Who is for the pension department? Yes. Have you seen the judgment?
Otherwise, may dispose of that in the department concerned to verify whether that.
They have already submitted the papers.
That's what happened. I just
Uh-huh.
want to know about it.
Okay, heard learned counsel for the parties. M. Runmani Deka for PWD,
No, Your Lordship, for water resources.
Water Resources,
I'm on behalf of Mr. R.M. Das. Your Lordship.
on behalf of Mr. R.M. Das. Mr. Bora for pension. And Mr. Nayak for finance, treasury officer. Yes. MS so for accountant general. This matter stands covered by the judgment of this coordinate bench rendered in WPC so by judgment in order dated
Yes, 34, madam.
4/12/2018. By this judgment, the coordinate bench at this court has directed that deduction of 6 years in computation of the mandatory period required for a person to be eligible for a master role workers to be eligible for pension. Has been held to be not reasonable and fair. The writ petition accordingly stands closed in terms of the above disposed. It is further submitted by the learned standing council of water resources that the concerned pension papers have already been forwarded to the office of the pension department, accountant general,
On 9/10,
on 9/10/2023. Stop. Accordingly, the respondents will complete the process for release of pension by keeping in view the orders of this court as well as the orders passed in WPC so and so. Disposed.
Within a period of, my lord.
Ah,
Within a period of, my lord.
not within a period, let them do it. It'll take some time, they'll get it done.
Lord, why am I paying for response number 6?
We have recorded.
Lord.
Yes. Yes, Mr. Das.
Look, this is a matter, the petitioners before your lordship are all the retired block development officers in the Department of Panchayat and Rural Development. The grievance is that, my lord, ROP rule 2017 initially revised their pay from the pre-revised pay of 8,000, 35,000 to 22,000, 87,000 as per the ROP 2017. After that, government issued another notification amending the ROP rule by which they were placed to 30,000 to 1,10,000 with 12,700 grade pay. Now the problem herein is that, my lord, this 30,000 to 1,10,000 was given from 1/4/2016. Now, since this has been incorporated newly in the ROP rule, so there is no fitment table available corresponding this 30,000, 1,10,000 to the pay of 8,000, 35,000. If I take your lordship, if your lordship kindly take up the ROP rule for a moment, I can, my lord, show to your lordships the difficulty the petitioners are facing.
ROP rules. Is it available here
Uh,
in the
yes, my
pleadings?
lord. All the
Revision of pay.
one fitment I have annexed, but if your lordship kindly take up but I'm sorry, I have annexed only the relevant portion, the entire ROP I have annexed.
Where is
For a
that
moment,
letter?
lordship,
Where
can
is
we come to page 44 for a moment?
where is that letter 2/3/23?
2, 3,
23, annexure
yes,
21.
page 80, my lord. আমার কিতাপখন আমাৰ আৰু এখন আৰপি আছিল নহয়
Yes. Page 80.
Page 80, my lord. With reference to your letter cited above, I am directed to inform you that for fixation of pay of block development officers on 1/4/2016, the procedure shown at case 1A of appendix 6 at page 350 in the Assam Service ROP Rule 2017 may be followed. Annexure A1. The amended table 1.18 as per notification number so and so is enclosed below as annexure 2. This case 1A is not connected to the present petitioner. Why? In the case of petitioners, my lord, not only their grade pay has been they were placed in a higher grade pay, their pay band and PB was also taken to a higher level. So there has to be a fitment table. My lord, I am just giving a lot of my book, my lord, that that will help you a lot to understand.
Yes. Page number?
Lordship got the book, man.
This one?
Lordship.
Yes.
$8,000 to $35,000
No, page number.
Yes, I'm just giving. you. Page in the top 330, right hand side, top middle.
No, P30.
Right hand side, top,
Which department is it?
table number 1.18, my lord.
No, your petitioners are under which department?
Panchayat and Rural Development Department.
Panchayat and Rural.
Yes, ma'am. That portion, your lordship, I have annexed in the writ petition also, relevant portion of the ROP rule. That your lordship will find page 44. Page 44 of the writ petition.
One minute. Yes, Panchayat and Rural Development.
Yes, page 44, lordship got my lord?
Not 44 from this book.
Yes, fine. my lord.
Directorate of Panchayat and Directorate of Panchayat.
Yes,
What are the posts?
block development officer. ma'am.
Block development. This will be under Panchayat or Rural Development?
Yes, Panchayat and Rural Development Department, and then Directorate of Panchayat. Serial number, my lords, will be 1, 2, 3, 4, 5, 6, 7, 8. Block development officer.
Yes.
Lordship will see PB3,
Hmm.
8,000, 35,000.
Hmm.
Grade pay 4,700
Yes.
has been taken to PB3, 22,000, dash 87,000, and grade pay 10,900.
Hmm.
This was the recommendation of the ROP rule initially.
Hmm.
Then, if your lordships kindly turn to page 45 of the writ petition.
Hmm. Yes.
In exercise of the powers conferred by proviso to Article 309 of the Constitution of India, Governor of Assam is pleased to order the following amendments shall be made in the schedule to the Assam Service ROP Rule 2017, published in the extraordinary issue of Assam Gazette so and so, under the notification dated so and so. The pay schedule under the head Panchayat and Rural Development Department, below the subhead 1 Directorate of Panchayat, the following existing entries in column 4-5 against the post of block development officer shall be substituted as below. So what they did, my lord, block development officer, 8,000, 35,000, the pre-revised, 4700 was the grade pay, pre-revised. They placed it in PB4, 30,000 to 1,10,000 and 12,700 grade pay. So in between the 22,000, 87,000, that has been, my lord, stepped down, and that was, my lord, taken over above 22,000. That means one rank ahead in the ROP rule. From PB3 to PB4, 30,000 to 1,10,000 and grade pay 12,700. Then, my lord, will kindly come to page 46.
Upgraded to when
Yes,
PB3 to PB4.
PB3 to PB4. The significant aspect is that with effect from 1st April 2021, they gave it prospectively. Then the petitioner approached this honorable court and submitted a representation. Pursuant to that representation, the government could realize their mistake, and they passed this order. Your lordship will find page 58.
No, what is your representation?
You know, these representations were regarding, my lord, with regard to giving it prospective effect. Initially, we said that you could not have given it prospectively because our pay were revised from 8,000 to 35,000. From 8,000, 35,000 to 30,000, 1,10,000. It has to be, it has to relate back to 1/4/2016.
Yes. Then,
You could not have given us from prospectively. Then page 58, annexure P9. In exercise of the powers conferred by the proviso to Article 309 of the Constitution of India, the Governor of Assam is pleased to order that the pay structure of PB4, 30,000, 1,10,000 plus grade pay 12,700 for the post of BDO as allowed by notification dated so and so shall be effective from 1/4/2016.
Hmm.
That means from 1/4, this 30,000, 1,10,000 plus 12,700,
has been made.
we are
effective.
entitled from 1/4/2016. Now the next problem comes, how to do the fixation, my lord. Because your lordship will, if your lordship kindly take up the ROP rule, page 330 in the left hand side, my lord.
Yes.
Table number 1.18.
Yes.
This is the first, this is the, my lord, replacement pay scale and pay band provided by the ROP rule originally, not by the amended one. So 8,035,000 revised was given initially, that is 22,000 to 87,000.
Yes.
So, say for example, my lord, if we take up the serial number 1, if a person is getting on 31st March 2016 basic pay of 12,700, then his pay after revision comes to 22,000 plus grade pay 10,900, then comes 32,900. What I am trying to, my lord, place before your
No,
lordship is
32,900 is the total, comprising
total.
of the grade and the
Adding the grade
pay
pay.
band. Yes.
Adding the grade pay. So if we take this example, my lord,
Hmm.
by this table, we are having some, my lord, data or some pay amount by which we can transform this 8,000, 35,000 to 22,000 to 87,000. What we do is that if a person is getting 12,700 on 31st March 2016, so we see whether he is getting 12,700 or 13,090, and accordingly we revise his pay. By placing him, if he is 13,090, then we fix his pay 22,990, add his grade pay, and we get the total basic pay.
Yes.
Now, this 22,000, 87,000, we don't have any problem. But the government had amended this ROP rule and gave us, my lord, 30,000 to 1,10,000 with grade pay of 12,700. That your lordship will find in the next page, table number 1.12.
1.12. Yes.
So, a revised pay band of 30,000 to 1,10,000 with grade pay of 12,700 corresponds to a pre-revised pay and grade pay of 12,000 to 40,000 and 5,400. This is not 8,000, 35,000, my lord.
No, you're referring to 1.12, previous table.
No, I am referring to table number 1.21.
Say that.
I'm sorry, my
1.21.
lord. I'm sorry.
Yes, 1.21.
So my lord, 1.21, Lordship will kindly see revised PB 30,000, 1,10,000, grade pay 12,700. So this corresponds to pre-revised pay of 12,000, 40,000 plus grade pay 5,400. But we were getting 8,000, 35,000 plus 4,700. So this is not our pre-revised pay and grade pay. So if today you want to fix us or revise our pay in 30,000, 1,10,000, the finance department is required to provide a fitment table which corresponds this 30,000, 1,10,000 to our pre-revised pay and grade pay. Because if your lordships kindly take for an example serial number 1 17,400, we will never get 17,400 because in 12,000, 40,000 in this pay we never born. We were in 8,000, 35,000. Our next one was 22,000, 87,000.
Hmm.
So this next, my lord, that was overlapped and we were taken to the
Next higher.
next higher. So when you are fixing to the next higher grade pay and pay, you are to provide a previous this next higher fitment table is to correlate to our pay and grade pay,
Which you had received earlier.
which were received earlier. So if you follow this 1.21 table and 1A, which is in fact not related to us, that there will
According to you, it is to be which table? 1.18.
my lord, we provided one table, my lord. For an example, my lord, we have annexed that table we provided, but the department is not considering that. Lordship will kindly see page 75 for a moment. In fact, AG also, my lord, wrote letters, 3-4 letters, asking the finance department that you provide us the fitment table. Without fitment table, we cannot issue pay slip and revise their pay.
Yes.
Milord, this was the page 75 is a pro forma fitment table that we provided, Milord.
You
Along with
provided. You provided on what basis?
Milord, Lordship will
On
kindly-
your understanding.
that is, Milord,
Your
we have
calculation.
also consulted, Milord, experts in this field, Milord. Sir, we are not
So
saying that you do this.
You fall under which fitment scale now, as per this table?
As per page 75, Milord, 30,000 to 1,10,000 and grade pay 12,700. Lordship will find here that 8,000, 35,000, that is the
Original.
original we were getting. This is the revised corresponds to the pre-revised. So in this manner, it has to be done. I am not saying that you give this amounts or you,
What is your grade pay now? In terms of, no, in terms of, see, earlier it was 8,000, 35,000. Now it has gone up to 30,000 to 1,10,000.
yes,
So according to you, and you are receiving a grade pay of 12,700.
700.
So the fitment
Issue is not the grade pay, my lord.
fitment difficulty is that you are actually receiving 4,700 earlier. Is
Yes,
that 4,700? So therefore you should now fall under 12,700.
grade pay is not an issue. Here, grade pay is not an issue. Grade pay I'll get.
Uh,
But issue is the pre-revised pay, that is column B.
hmm.
This column B in the ROP rule is not existent. If your lordships kindly see the column B of fitment table 1.21, this fitment table does not correspond to 8,000 to 35,000. There where the problem lies. Because we have our this column B pay in the
You fall under 1.20. No.
no 1.21.
No, 1.21 does not correspond.
That is where the
So you should have been fitment ought to have been calculated under 1.19.
Milord, after the amendment,
Uh.
this 1.19 doesn't apply to us
Okay.
because we were already taken to the next higher pay. That is 1.21, 30,000 to 1,10,000. Had it not been given to us 30,000 to 1,10,000, then Milord, it's correct that 1.19. But when we were taken to 1.21, the government is required to give this column B. That means a new fitment table, a revised fitment table for this particular thing, Milord.
Hmm.
And it is not the case the government has not done it. Government has done it in other cases.
Hmm.
The AG also repeatedly wrote 3-4 letters to the finance PRU department saying that give us the revised fitment table, but they are not giving it. If I take your lordships, one of such letters of the AG.
Who is for the finance?
Finance.
Have they filed their affidavits?
They have filed one affidavit, Milord.
What does it reflect?
They, Milord, what they have done, initially they applied 1A and fitment table 1.21. Then they cancelled their own communication by passing an order. After that, they again resorted to that fitment table 1.21 and case 1A. And they are saying that our pay has to be fixed as per fitment table 1.21, which doesn't even have our pre-revised pay, that is column B. My lord, can have this AG later, what AG is of the view?
Page number?
Page 59, my lord. Not only one letter, several letters AG wrote. May I read, my lord?
Yes.
In inviting a reference to government notification dated so-and-so on the subject cited above, I am to state that the government-wide notification dated so-and-so has allowed the pay structure PB4, 30,110 plus grade pay 12,700 for the post of BDO as per government notification dated so-and-so with effect from 1/4/2016, and also set aside the PNRD department's notification dated 29/7/2021. This I'll refer to your lordship, my lord. In this connection, this office letter dated 23/6/2020 may kindly be referred to. The required fitment table for the revised scale of pay structure PB4, 30,000 to 1,10,000 plus GP rupees 12,700, corresponding to PB 8,000 to 35,000 plus grade pay 4,700 ROP 2010 with effect from 1/4/2016 does not appear to have been sent to this office. Unless the fitment table is received, this office is not in a position to fix the pay of the BDOs and authorize the revised pay and allowances with effect from 1/4/2016. In view of the above, the government is requested to furnish the fitment table for the revised scale of pay structure so-and-so corresponding to 8,000, 35,000, 8,000 plus grade pay 4,700 for taking further necessary action at this stage. So it was a very simple exercise, my lord. And not only this, my lord, they have thereafter, my lord, what they have did, my lord, the finance PRU, page 60. They say, I am directed to inform you that the government in finance department has already issued a notification dated so-and-so, allowing upgraded pay structure so-and-so for the post of BDO as allowed by earlier notification dated so-and-so with effect from 1/4/2016. The notification issued in so-and-so is set aside 29/7/2021. That is prospective, giving prospective effect that was set aside. For fixation of pay of BDOs on 1/4/2016, the procedures shown in case 1A, this lordship will kindly mark, case 1A of appendix 6 at page 350 in Assam Service ROP Rule 2017 may be followed. The amended table 1.18 as per notification dated so and so is enclosed herewith annexed 2. Now, in the next page, page 61, they cancel this page 60 decision, my lord. Also, will kindly see down below, this cancelled earlier letter dated 14/7/2022. This 14/7/2022, whereby decision was taken to follow case 1A, appendix 6 at page 350.
Yes, yes. Who's for the finance?
Yes, my lord, finance, my lord.
Lordship, Mr. R. Bhaur Pujari appears in the matter, my lord. He is in bereavement, my lord, because some
You should have informed us.
Lordship, I was just informed, Lordship. I apologize.
I'm
Let us
sorry,
have it.
my lord.
When is he likely to be?
Lordship,
available?
after 1 week, Lordship.
All right, matter be listed again on 7th December.
Lordship,
70.
You are wasting judicial time.
Lordship, I apologize. Lordship,
The apology, what you should know and make a mention before that.
Lordship, I'm at.
The submitted matter be that standing counsel, Mr. Corpusari and bereavement. Understand? But
Highly, much of.
7.
70.
Mr. H.K. Das for petitioner, Mr. Kalia for finance, Mr. Hassan for accountant general, Mr. Devnath also, PNR. Yes.
Deeply.
Maybe.
Yeah.
But in this case, my lord, the impugn order, the impugn communication, not order, communication, page 33, has been issued by the LICI, whereby my pension has been stopped, my lord. The dispute with regard to pension has been settled by this Honorable Court earlier, page 28. The order is there. I was serving in the ONGC, and my pension was paid by the LICI on deposit of an amount of rupees 54 lakh, my lord, earlier. Now it is 36 lakh on the basis of corpus amount, my lord.
Yes.
Whatever, I opted for withdrawal of, my lord, 1/3 of the amount and of the principal amount, my lord. And this was consensus, my lord, allowed, my lord. And thereafter, they have given me the amount, my lord, 1/3 amount they have deposited in my account. And my lord stopped my pension, my lord, asking me to refund the amount of rupees, my lord, 10 lakhs to 7 lakhs, my lord, to them. 7,26,117 to them. For the period with effect from date of my retirement and till the disbursement of the amount, my lord.
Who's for LIC?
Yes. Right, please, Your Lordship.
Yes.
So I have filed affidavit in opposition in this case.
Hmm.
In regular page 37, I have already stated the petitioner purchased the annuity from the LIC, and accordingly LIC calculated and paid the monthly pension 30,000 608, and thereafter they filed a writ petition before this honorable court, and it was considered, prayer of the petitioner considered as a special case, and accordingly the LICI complied the said order of the honorable court and paid the 1/3 commutation to the petitioner. But during the period 1/4/2007 to 1/3/2023, the excess amount obtained by the petitioner, which is paid by the LICI, accordingly the then annuity amount. So while the 1/3 amount later on 1/3 amount claimed by the petitioner and
LIC also paid the same, but LICI paid the excess amount to the petitioner, which is claimed by the LICI to refund to the LIC. So they are not
So how much amount you had given him? 1/3?
1/3, yes.
1/3.
Yes.
So according to you, this 1/3 calculation, there was a wrong calculation. You had given him more amount.
No. Actually, first time total corpus amount 54 lakhs.
8,250.
54 lakhs or what?
Yes. And that is the purchase amount. And accordingly, the annuity on the basis of that purchase amount, annuity paid by the LICI 30,680.
Yeah.
And it is paid from 1/4/2017 to 1/3/2023. Thereafter, they claimed 1/3 commutation amount and 1/3 commutation amount, and LICI also paid 1/3. It is
18 lakh.
18 lakhs.
300. 18 lakh 2,300.
18 lakhs 200.
2,379.
So this is the second time it is paid, and total amount, it is total amount from 54 lakhs 8,215. It is converted the core amount 36 lakhs 058,036, and the installment later on installment will be paid by the petitioner to the will paid by the LICI to the petitioner 20,461 as per total amount 2/3. Two-third already deposited in the LICI, 1/3 already taken, and per month LICI will pay 20,461. That is pension amount. So the excess amount during the period 1/4/2017 to 1/3/2013. So excess amount, that is per month 10,000. Fellowship.
You give a chart properly.
Let me explain, my lord. This is given.
Where is it?
My lord, it's in the impute order itself, my lord. 33, page 33.
Page number 32.
Page 33 of the writ petition number.
33, okay.
Yes. It is clearly written there.
Yes.
What happened, my lord? Petitioner retired in the month of January, my lord, 2017. At the time of his retirement, the ONGC has deposited an amount of rupees.
We have understood that. You
Yes.
have withdrawn one third.
1/3 withdrawn. Now what they are asking, my lord? The amount they have taken for 54 lakhs for the period 1/4/2017 to 1/3/2023.
For which you have been given 30,000.
30,000. Now it is reduced to 36 lakhs and I'm entitled for 20,000. But what happened, my lord? They are asking for the money what they have given against that 1/3 what is returned to me. That amount they are asking, my lord. My money they have kept with them. They have given me against my money. Now my money is reduced. The reduced amount will be paid. Now they are asking me that, my lord, they're assuming that my money was 36 lakhs with effect from 1/4/2017. And that's why, my lord, they're asking me to refund the amount against 1/3 of money, 1/3 of the total amount, which I have received, my lord, against total amount of 54 lakhs. This is their case. That cannot be, my lord.
No, their case is that they had given you 30,000 or
Yes.
as per their calculation.
Yes.
Then halfway through you withdrew 1/3.
Yes. Yes. With effect from 1/4/2014, 23.
So according to what is the total amount calculated from 1/4/2017 to 1/3/2023?
It was 30,000, my lord, 688.
No, no, at the rate of 10,227.
Yes, 7 lakhs. It is 7,26,170.
Why do you want to recover this amount from him?
This is excess amount because he purchased the scheme, LIC scheme. So
You
the
adjust
amount also
You
calculated.
adjust it according to whatever he is supposed to get. What is the balance amount for him now?
My lord, my total amount is 36 lakhs with them, and against that man, I'm entitled for 20,461.
For how many years?
It is for lifetime, my lord. It is lifetime.
No, it's not for lifetime. It's that 20,000 into up to that amount is exhausted, isn't it?
No, no, no,
36.
no, no.
20,000, that is after getting the 1/3.
I know. Now, for how many years will you pay him 20,000? For life?
Not for life, it is 15 years.
Then
It is not life, bro.
it's not for life.
Life.
15 years.
Where is that? What do you call it?
Page 17, my lord. Then the page 18, 3, Annex 3 ML. It's a pension, my lord. Settlement of pension claim in respect of such and such under ONGC. Total amount deposited, my lord. And page 19 is the settlement of amount.
You show us that LIC document. Where is it? Do you have it,
No.
Mr. Counsel?
My lord, they have not, this form is only with us, my lord. Form and the pension order, a certificate of annuity.
The form is not mentioned. It's 15.
See, you come to page number 19. Certificate of annuity.
Yes.
So your total purchase price is 53,991.67.
Yes.
So this is the amount we have given them.
Yes.
And they will give you 3640.
Yes.
Now, out of that, in terms of ONGC, you are entitled to withdraw 1/3 of 53,99 something. So that amount you have taken back.
Yes.
So now
The
this
pension,
amount has gone below and 20,000 something
20,000.
you have got it.
Yes.
But according to their calculation, they have started paying you 30,000 from 1/4/2017.
The money has been paid to me, my lord.
I know it has been paid to you,
Yes.
but it will be paid only till the amount of 53,991.67. So now the calculation will change. You will have to now satisfy that notwithstanding 20,000 something. Either you'll have to calculate this 10,000 amount, which you have already got, excess, according to them. Adjust it with your now monthly payments. or adjust it at one go. So therefore, what is the total amount? Say 10,227 per month for this period. What is the amount?
7,26,170.
7,23,170. So this amount you have to adjust it.
My lord, they have, our case is that, my lord, they have kept my money with effect from the 17 to
Oh, they have kept your money to 53,000,
53 lakhs, my lord.
53 lakhs.
Uh,
So beyond that, it is not your money.
Yes.
So
They-
now, according
have-
to their calculation, Mr. LIC, you have to revise this calculation. Why are you asking for payment? Why are you trying to recover the amount from him? You
Yes.
adjust it with the balance amount which is to be paid.
Yes.
Your scheme may say anything unless you want to show us that yes, there is a contract executed.
So it,
Come to page number 33. This is the recovery you want to do, 7,26,117.
yes.
Now this recovery, instead of recovering it, you adjust it with the amount which is available.
Uh, so 1/3 amount already paid.
Whose amount you are paying? Is it LIC's money?
Unless,
No, it is deposited by him.
yes.
Then you are giving him back his money with an element of interest. It is not LIC's money.
The interest which they have paid, my lord, they want to take it back, my lord. That is the case, my lord. They have paid me 30,000 against 54 lakh.
So that can be adjusted with your residual amount. Will have to be adjusted.
Because they have utilized my money, my lord. Against that utilization, they have paid me 30,000.
That is between you and LIC. That is why you are asking for the agreement. You show us the agreement.
Yes, which is,
Where is it?
that is,
That you have conveniently not placed before the court.
no,
Because all these terms and conditions will be there.
in the earlier round of
There is
litigation,
an ombudsman. You go to the ombudsman and argue your case there.
in the earlier round of litigation, my lord.
Earlier around nothing. It was a consent order.
Yes,
Then
they've agreed.
it was a
to
consent
pay.
order.
They've agreed to pay, and accordingly they paid.
We produce that document. You produce that what do you call it?
What is it?
Policy.
Police like with them, my lord. It's not with my petitioner. They can produce.
Why will it not be with him? On what basis? What documents have you received from LIC with regard to the deposits made?
It is given by the ONGC only the certificate at the time of retirement, my lord.
Then it must be with ONGC. Yes.
Either the ONGC or the LIC they have.
Anyone for ONGC? You are for ONGC? Tell us. Are you for ONGC?
Yes, Lord.
Is there anything you want to submit?
Lord, yesterday I have received an affidavit in reply from petitioner, and in this reply, in para 6, they have stated the deponent ବ୍ୟক্তি stated ONGC authority has the knowledge that at amount of rupees 10 lakh is payable on account of gratuity accrued to the petitioner during the service period, but till date the same has not been credited to the account of the petitioner. But Lordship, I have
Affidavit in reply.
replied.
You have filed some affidavit in reply.
It may not be in the yesterday file, my lord.
Huh?
It may not be in the record.
It is not here in the record. When did you file it?
Yesterday.
It is submitted by the counsel for the petitioner that an affidavit in reply has been filed. However, the same is not available in the case records. Registry to verify and press the affidavit and connect it to the case record. Please next week. Yes, you get your instructions and tell us why you cannot adjust it with the balance amount. That is all. And if there's anything in the policy, you show it to us. It is a contract. It may be unreasonable, but it's a contract. Show it to us next week. Yes.
But in this case, my lord,
No affidavit.
no affidavit has been filed, my lord. Here the issue is
Who's for the elementary education?
elementary and finance, mainly finances to file the
Your
affidavit, my lord.
affidavit is required.
The second round of litigation.
Finance to file the affidavit, otherwise we will.
The second round of
No,
litigation.
the permission, yes, finance and elementary both have been given 4 weeks to file affidavit.
Yes.
We receive instruction, we will file, but mainly the finance.
Where is the earlier order?
Earlier round of litigation, my lord. The impugn order is page 96, my lord.
96.
What happened, my lord, in this case? Wrong fixation of salary.
Yes.
The person who has been appointed in the year 2011 and who has been appointed in the 2016 will get the same salary, my lord. As per if the formula they have provided is followed in the fixation of pay structure, the 5-year service of the petitioners will go. What happened in the ROP 2017, my lord, the grade pay and the pay band of the post of SI of schools have been upgraded from earlier.
Lordship, here Mr. R. Bor Pujari appears, my lord. He is Lordship, bereavement, Lordship. Lordship, if the matter can be fixed on the 7th, Lordship.
Not 7th, I think 7th, many cases are there.
You have to file your affidavit.
They have to file affidavit.
The education and secondary education and finance prays for further time to file their counter affidavit list after 2 weeks. 2 weeks?
It's the second week of any date marked in the second week of December.
Second week, yes, after 2 weeks.
It may be 20th or 19th.
14.
Obliged.
14 December. Let them first file the affidavit, then you make a mention. Definitely.
Field officers matter, my lord.
Covered.
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 Yes.
Yeah.
This is the order, my lord.
Yes.
Only your lordship, since the connected matters, your lordship, that part of field officer for a period of 1 year, it may be deleted, sir, because in some cases it's 3 years, because the order your lordship is going to pass common. I think it's good. 8 to 7.
8 to 17.
Paragraph 2, your lord.
You mentioned about what is to be deleted?
Paragraph 2, your lordship will find going to submit that the petitioner was appointed on contractual basis as field officer for a period of 1 year. It may be deleted. Otherwise, everything is there.
All right. Disposed.
Deeply.
Respective council.
2, 3, 4, I'm making. I pay for respond number 1.
Mr. Dotto for 2, 3, 4. Mr. Bora for 1. And Mr. Cholia for
5.
For
5.
5.
Deeply. How like?
None appears for the petitioner on call. None had appeared for the petitioner earlier when the matter was called on. 21/12/2012, 22/1/2013, 14/11/2023. Accordingly, writ petition dismissed for non-prosecution. Mr. D. Bora for the respondents. Interim order, if any, stands vacated. Interim application, if any, stands dismissed. 28.
Lordship, yesterday we have filed affidavit in opposition, Lordship.
You filed something, yes.
Let's
Some
see.
affidavit has been filed.
Reply is not necessary, my lord.
No, but
Only
it is, has to be available in the
Yes,
file.
the one date may be fixed for
It is submitted by MS
Z Bora,
G.
Lordship.
Bora, learned counsel for the respondents that
1 and 2.
uh,
1 and 2 Agriculture Department,
1 into Agriculture Department that an affidavit has been filed,
Lordship.
which however is not available in the case record. Mr. B. Chakraborty, learned counsel, appears for the petitioner. Let the registry connect the affidavit stated to be filed, stated to have been filed, and list the matter. When
Tuesday next, my lord. I'm not getting pension from 2004, my lord.
you are retired from service.
2004, I have retired, and only issue that they are saying a criminal case is pending. As per law, they cannot do it, my lord. This is the only issue, my lord.
All right.
That's why reply is not
7 December.
Hello.
List on 7 December.
Please, your lordship. Lordship, this matter may be taken at 2.
Who's for the petitioner?
For the respondent.
Let us wait for the petitioner. Okay, at 2. Let's see. At 2. Item 19 on council. It does. Did you? Yes.
May
Mr.
please,
Puri.
this petition has been filed challenging the imposition of stoppage of 2 increment with cumulative effect and suspension period without duty. My lord, a charge sheet was issued, my lord, that year on 23/3/2011 at page 25.
So first tell me, this matter rule was issued on 6/12/2012. Next date is on 2018. What happened for 6 years?
May I please, your lordship?
The petitioner lost interest.
No, my lord.
The council must have lost interest.
It is not our fault, my lord. To be honest, my lord, as soon as rule issued, my lord, earlier, it goes to the cold storage. To be honest, without blaming anybody, my lord. That's the difficulty, because as soon as issued rule, the case will be listed for hearing. Hearing means there earlier all cases are there. Always these cases.
No, but
As soon as
if it is leftover, then some endorsements are given by the office that it is to be
now in the computer, even if I will find it that some references there earlier not there. Leftover in hearing list, my lord, no such record was meant.
Then perhaps the council lost interest in the meanwhile.
No, my lord, no, not at all.
Yes.
Lordship, kindly adjourn the matter for today, Lordship. My senior is out of station, Lordship.
Who is your senior?
Lordship, Zaki Goswami, Lordship. Lordship, day after tomorrow, Lordship.
Day after tomorrow. Day after 23rd.
Or Tuesday next, my lord.
We
Any
can
day,
have it on. Well, we can have it on 5th December.
My lord.
5th December.
Unduly
As
authorized.
it is submitted that the respondent counsel, Mr. J.K. Goswami, is out of station today. Mr. Kotoki appears for the Kotoki appears for the petitioner. List on 5th of December. None of it passed over. Double it. Second round. News for the petitioner. H. Gupta.
Lordship, petitioner earlier also filed one writ petition, Lordship. And at that point of time, matter was under consideration of the department, and accordingly, that case was closed. Subsequently, Lordship, at page 57, Lordship, this order was passed by the department, Lordship. And challenging this order, the present writ petition has been filed.
What was the direction in the earlier writ petition?
No direction as such, Lordship. As the matter was under consideration of the authority, Lordship, that is why the matter was closed. Page 56.
What is his grievance? Yeah.
Lordship, according to the petitioner, Lordship, last date, Lordship, direction was issued for instruction by the finance department, Lordship. That is also awaited, Lordship.
So it is a claim of area salary.
Lordship.
Then-
Anomaly in calculating the area salary.
So according to the department, this is the amount, 57.
Yes, Lordship. It was given with effect from February. It should have been, which was by oversight granted in the month of March 1992 instead of February 1992, and accordingly rectified. So according to the authority, it has been rectified, Lordship. Lordship, today, Lordship, I am praying for some time, Lordship. Finance department instruction is awaited. On last date, Lordship, department was asked to submit its affidavit.
For what?
For filing its affidavit, Lordship.
No, is it the case of the department that there is no arrear? Whatever was there in February has already been released in March.
Yes.
That is your stand.
That 1 month has been given, Lordship.
So initially, although not given, subsequently released in March.
Yes, initially it was given from March, but subsequently he was given from February, Lord.
Well, let us see at 2 p.m. if anyone comes.
Lord. In the meantime, he has retired.
You are appearing for this matter?
Brother, I am appearing for item number 23. Actually, my name is also in 23.
This
His
is
name was
item?
not shown.
No, this is 26.
But it is a covered metal of thing.
Huh? 26.
23 left.
No, not 23. 23 to you. If we call up again at this item 26,
Lordship.
we'll call it up at 2.
Lordship, let me have the instruction, Lordship. Now, my instruction is awaited, Lord.
Let the petitioner counsel be
Lord,
there
Lord.
because he may not be interested to pursue, then what is the point?
Lord.
Yes, item 23.
This matter is for non-payment of death cum retirement gratuity loan. Due to not having the minimum qualifying service lordship, same has not been paid, Lordship.
How many years of service?
Lordship, total service, Lordship, I have 10 years, 8 months, 8 days masteral period, 14 years, 5 months, workshops period, and 7 years, 11 months, 8 days regular period. Lordship. And while deciding to grant a pension, Lordship, the authority consider my qualifying service, Lordship, which is at page 18, Lordship.
Hmm.
18. 18 years, 11 months, 16 days, Lordship.
Hmm.
Lordship, if some portion of workshops period are counted, Lordship, pursuant to the recent judgment passed by the Honorable Supreme Court, Lordship. And even, Lordship, my case is covered by the Sanjita Roy. But very recently, Honorable Supreme
No,
Court has
Sanjita Roy is deduction.
deduction, Lordship.
Ah.
Deduction.
Has any period been deducted here?
Yes, Lordship. Deducted, Lordship.
Where?
Your Lordship may kindly come to the page number 18, date of joining, 7 to 1965.
Hmm?
So, Lordship. Date of joining 17/7/1991.
Ah.
Date of date 1/7/2000. Lordship, 13, Lordship. Gross service, Lordship, 21 years, 11 months, 16 days, Lordship. Non-qualifying service, 3 years, Lordship. It is period deducted, Lordship. And so net qualifying service, 18 years, 11 months, 16 days, Lordship. That is why, Lordship, I am not paid the DCRG, Lordship. And if that period is counted, Lordship, I will be entitled, Lordship. This is only the case, Lordship.
Now you show us Sanjita Roy.
So, not very recently, Lordship, Honorable Supreme Court passed on judgment, Lordship. And so far, Lordship,
Gujarat, from Gujarat High Court.
no, Gujarat, Uday Prasad Thakur, Uday Pratap Thakur, Lordship.
Let us see.
So far, Sangeeta is concerned, whole period of service is required to be counted. And here the Honorable Supreme Court held it. That the finding of court for the purpose of pension only such period from the work start renew would be added for making the service of an employee who has been regularized to qualify him for pension. My service was regularized. Lordship.
Uday Pratap. এটা কি হলো পেনশন তো কমে যায় হ্যাঁ পেনশন তো ফ্যামিলি পেনশন এটা ফ্যামিলি পেনশন আছে সেন্টিটারের দরকার প্রবলেম কি হচ্ছে
Who's appearing for the respondents here?
Education.
TWD,
Yes,
Accountant
Lord.
General.
I'm appearing for 1 and 2, Lord.
1, 2.
Now here, Lordship, the petitioner is getting the family pension, Lordship. So far as pension is concerned, Lordship, no issue is there.
No issue. I have no
He is claiming DCRG.
DCRG, Lordship.
So why DCRG is not released?
Due to not having 20 years of qualifying service, Lordship.
That is it not settled by that earlier judgment?
There was a clear stand from both from the Accountant General and the PWD, Lordship. Due to not having 20 years of service, I have not been paid by the DCRG.
DCRG relaxation হয় না okay can I get it?
Who's for the pension? Accountant General.
In this case, Lordship, it will be AG, Lord.
AG.
MR worker.
Tell us whether DCRG is available to him or not.
As per our affidavit in opposition, the petitioner has not completed.
Why? Why?
20 years.
Page number?
Running page, Lordship, 31, Lordship. Accountant General affidavit.
31.
Yes, then this is page lordship.
31 is PWD.
No, no. Accountant General affidavit lordship. Filed on 18/9/2015. Here stand is a paragraph number 5 lordship.
Let us see pension.
Okay. Lordship, there was one same case, lordship. I was the counsel. In that case also, accountant general denied his DCSG lordship. And lordship, their stand was that due to not having qualifying service. Subsequently, lordship, pursuant to court's order, lordship, DCSG was released, lordship.
Where is that order?
Court's order is not, it may actually court, there is court monitored that matter, lordship, and during the pendency of the retribution, lordship, his DCSG was sanctioned. I have annexed it in my reply affidavit. My reply affidavit running page probably lordship 36. And the accountant general order is at page 51, lordship. Here, lordship, that incumbent DCSG was sanctioned. In that case, his qualifying service was 17 years, 8 months, 23 days, which was less to that petitioner.
Mr. Counsel for Accountant General, I think come to para 6 of your affidavit, page 35. You're saying that he is not eligible under Rule 136 and 152. You show us from Rule 136 and 152 how it is not applicable. You have a rule, copy of the rule? Meanwhile, in this Supreme Court judgment, which paragraph you're relying on?
We have page number, second page, lordship. Here the findings of the court for the purpose of pension only.
Paragraph.
Paragraph only findings, lordship. Findings of court for the purpose of pension only such period from the work as tenure would be added for making the.
You are reading from which paragraph?
Lordship, second, page number 2, Lordship.
Huh.
Second paragraph, Lordship, findings of court.
Findings of court.
Findings of court. And paragraph number 7, Lordship. Here the appellant claim for counting the whole work period, Lordship, and it was negated, and directed only to count the requisite period, Lordship.
No, I'm referring to the Supreme Court judgment.
Lordship.
Yes.
I think that this will be more applicable than to the Samhita Rai. Samhita Rai, so far Samhita paragraph number 31 and 30, whole period of service is required to be counted. But so far Supreme Court is concerned, Lordship, only the requisite period of services is required to be counted. And I will be satisfied, Lordship, if at least that figure is considered, I will get
You
the
take
benefit.
out Prem Singh.
Prem Singh also, Prem Singh is actually in that case, Lordship, Prem Singh also described. And paragraph number 36 of Prem Singh. There are some of the employees who have not been regularized in spite of having rendered the service for 30, 40 or more years, whereas they have been superannuated, as they have worked in the workshop establishment, not against any particular project. Their service ought to have been regularized under the government instruction and even as per the decision of this court, State of Karnataka, Umarebi, this court in the said decision has laid down that in case services have been rendered for more than 10 years without the cover of court's order, one time measure the service be regularized for such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as a regular one. However, it is made clear that they shall not be entitled to claiming any dues of differences. Here, Lordship, for regularization, this same thing is.
Yes, Mr. Counsel.
In Lordship, in Rule 152, when comments, it is reflected that pensionary benefit is also admissible to government servants rendering 20 years of continuous service without being confirmed in service. But it is not stated that pensionary benefits is applicable to below if hasn't completed.
How many years have you put in?
Lordship, if a whole period of service is counted, then it will be, Lordship, more than 20 years.
21 years.
21 years. And if the master law period is counted, then it will be 34 years. Lordship.
Completed 21 years of service.
Lordship.
But Lordship, 3 years is deducted as per the government of Assam PPG department.
No, then you'll have to take in the services which is rendered earlier while calculating that. You read this judgment. Come back at 2 o'clock. You read this judgment. And there is another judgment referred here, Prem Singh.
Prem Singh.
Read it. Right. Copy will take.
Wait, please, Lord.
Yes.
This matter
Why
pertains
this matter
to-
is for hearing? What is the issue here?
The issue here is regularization of service of the petitioner. I am praying here to giving effect to my regularization since the date it was actually due, and to count my service for consideration of pensionary benefits as per the old pension scheme of 1969. So I am partly agreed by an order by which order of appointment was issued in the year 2020. If I may take your lordship to page 42 of my writ petition.
42.
I'm aggrieved by condition imposed by the authority, whereby I was asked to put my signature on a condition which is detrimental to my career. Thus, the appointee shall have to furnish an undertaking along with the joining report as prescribed in the finance department letter so and so regarding introduction of new pension rules. The content of the undertaking is as follows. I understand and accept that government servant joining the service of the state government on or after 1st February 2005 shall not be governed by the existing Assam Services Rules 1969, an order issued thereunder from time to time, and that their pension and other retirement benefits will be governed by a set of new pension rules which are being formulated in line with the contributory pension scheme of the Government of India and going to be notified in due course. It is further ordered that without above undertaking being furnished by the employee at the time of joining, the joining report shall not be valid as per rule. So I am challenging this order partially on 3 counts, my lord. The contract that has been entered into it adhesive in nature. It's unconscionable terms of contract. Your lordship is aware about Brojanath Ganguly's case, whereby court has held that the unconscionable contract is not maintainable, is void ab initio. And secondly, the terms and conditions that has been imposed on me, it is not as per the condition that has been given in the earlier writ petition. It was the third round of writ petition. I was appointed. The facts are something like this. I was appointed in the 1983 by a managing committee. Afterwards, I was through an advertisement, I appeared before a selection committee in the selection board as per the rule. The selection board, I was selected. My name was appearing in serial number 101. Many candidates whose name were appearing below me, after me, were appointed, given the appointment. Being agree, I approached this honorable court in the first round of litigation 1994. This honorable court, by way of an order, directed the authorities to consider my case on a compassionate basis, to consider my service and all this. After that, my lord, the authorities took more than 25 years to come to a conclusion that I am not entitled to be appointed as per 2004 circular. A person who is appointed by a managing committee is not a good appointment, it's a bad in law. So pursuant to that, my lord, 2016 order, my candidature was rejected. So I approached this honorable court in the year 2016. The order, this honorable court, by way of order passed in the year 2018, held that my service, which I was appointed in the 1993, my name was appearing in selection list of 1986 as per the rule, and as per the first judgment passed by this honorable court in the year 1994, a direction was given to consider my case. The authority did not do so, and 2004 notification, which says that the managing committee doesn't have the power to appoint a teacher, is not valid in law, because this notification came much after the judgment passed by this honorable court in the year 1994. So in this manner, my writ petition was allowed with a direction to the authorities to...
Where is that order?
The lordship will find this at page 36. Relevant portion started from page 37, if I may read.
Yes.
Paragraph 3. In the resultant situation, the petitioner approached this court by a writ petition, which was numbered as civil rule number so and so, which was disposed of by the order dated 17/1/1995. The order of 17/1/1995 inter alia provides as under. Having heard the learned counsel for the parties, I dispose of this writ petition with the direction that the respondent number 3, the Deputy Inspector of Schools, Bongaigaon, shall make an inquiry as to whether the petitioner had been working as assistant teacher in different Hindi medium LP schools for 10 years and consider his case sympathetically for regular appointment and absorption and pass appropriate orders within 2 months if he is found qualified and fulfill the requirements on the rule. The purport of the order dated 17/1/1995 is that the Deputy Inspector of School would make an inquiry as to whether the petitioner was working as an assistant teacher in different Hindi medium LP school for 10 years, and if yes, to consider his case sympathetically for a regular appointment. The said order dated 17/1/1995 has attained its finality in the meantime, Thereupon, various correspondences were made between the petitioner and the respondents, ultimately resulting in a report dated 19/2/2016 of the District Elementary Education Officer Bongaigaon to the Director of Elementary Education Assam. Prior to the said report, there was an earlier report dated 27/9/2011 of the Deputy Inspector of School Bongaigaon, wherein a chronological dates of engagement of the petitioner for 20 years had been provided, and the said chronological date indicates that the petitioner was in continuous appointment from 1983 onwards. The report dated 19/2/16 of the DEO states that the petitioner had been working with effect from 8/3/1983 till date. The said report was pursuant to the requirement of the order dated 17/1/1995 in CR number so and so, which had attained finality in the meantime. It is also to be taken note of that the petitioner had participated in the selection process for regular appointment, which was held in the year 1986. And in the select list, which is annexed as Annexure 3 to the writ petition, indicates that the petitioner was selected being at serial number 101, and that candidates below the petitioner in the select list were also appointed. In the report dated 19/2/2016, the DEO states that although the petitioner was selected by the advisory board in 1986, and he being at serial number 101, but was not appointed as there was no vacant post at 291 number Rashtrabhasha Vidyamandir LP School. The said select list, being a general select list, does not indicate as to how the authorities confine the consideration only to 291 number Rashtrabhasha Vidyamandir LP School, and not against the vacant posts that were available at that relevant point of time. Pursuant to the said report of the DO, the Director of Elementary Education passed the order dated 10/3/2016, which has been assailed in this writ petition. Although the order refers to the order dated 17/1/1995 in CR number so and so, meaning thereby that the director had passed the order in compliance of the requirement of the order dated 17/1/1995 of this court. But in the findings recorded by the director, there is no reference either to the requirement or to the compliance of the order dated 17/1/1995. The director goes out of way and refers to office memorandum dated 24/1/2004 and arrives at a conclusion that the said office memorandum states that there is no power of the managing committee to appoint teacher on honorary basis. This court does not find any relevance of the office memorandum dated 24/1/2004 inasmuch as the order in favor of the petitioner was passed by this court much earlier, that is on 17/1/1995, and therefore in compliance of the order, no reliance can be made to a subsequent office memorandum dated 24/1/2004. The order dated 17/1/1995, having attained its finality, crystallizes the right of the petitioner as provided therein, and therefore when the director considers compliance of the order, it has to be restricted to the provision of the order itself and not to any subsequent office memorandum or instruction that the government may have issued in the meantime. Secondly, the director also arrived at a conclusion that although the petitioner was working in different schools against leave vacancies, but such engagement were not continuous. The said conclusion also appears to be in conflict with the report of the DEO 19/2016, which says that the petitioner had been working with effect from 8/3/1983 till date, as well as with the report of the Deputy Inspector of School dated 27/9/2011, which shows that the petitioner had been in continuous engagement from the year 1983. For both the reasons stated above, the order of the director dated 10/3/2016 that was impugned in the order is found to be unsustainable, and accordingly the order is hereby set aside as agreed by the parties, and in view of the entitlements of the petition indicated above, the Commissioner and Secretary of the Government of Assam in Elementary Education Department shall consider the claim keeping in mind the order of this court dated 17/1/1995 and the select list of 1983 annexed and annexure 3 to the writ petition as well as. So pursuant to this order, when 2 years has gone by, the petitioner again approached this honorable court by another writ petition. Why I should not be appointed even though there was an order passed by this honorable court. Eventually, in the year 2018, they came up with an order of appointment, putting this clause, which is unconscionable terms of contract and which is adhesive in nature, putting me in a situation where I did not have any bargaining power. It's a case of unequal bargaining powers too, as held in the case of Usharani Goswami by this honorable court. Pursuant to this,
your appointment is with effect from which date?
With effect from the date of issuance of the order.
So 2020.
2020.
So 2020, you are covered by which pension routes?
2020, I am covered by the new pension scheme 2005, but my claim is something different. When my my appointment was due since the 1994.
Hmm.
When the first judgment was passed by this honorable court, it took 20
What was the first judgment? Where
first
is, where is
judgment,
it?
if I may take your lordship to page 22,
22.
annexure A. Relevant portion your lordship will find at page 25. Having heard the learned counsel for the parties, I dispose of this writ petition with the
So
direction
there
that
was
the
a enquiry, you make enquiry and consider sympathetically for regular appointment, pass appropriate order. This was not done.
this
Then
was not
comes
done.
the subsequent order.
It took 25 years for the authorities to came to a
Whatever
conclusion.
it took. But subsequently, the second order has come.
Second
16
order 2016,
2018.
16,
Huh? Where is that?
16 the impugn order. The order that was impugn in the
Ah,
writ petition.
subsequent writ petition.
Yes,
Whereby it was held to be rejected.
rejected. Then we challenged that order by
And
a
then
writ
the
petition.
matter was again remanded back by interfering with that earlier order.
Yes.
But while doing so, the direction of the court is that you consider the case in terms of the direction issued by the court in the first case.
Yes.
That is 95. So 95 direction is to consider your case sympathetically for regular appointment.
Yes.
So by this order, your case has already been considered sympathetically by regular order, by making your appointment regular. Now, only question is that you want to be, you want your appointment order with effect from that particular date.
1985. Otherwise, my whole career would have been at my lord at a stake, my lord, because
That I think is not, that is a new leaf to the original claim which you had in 95.
there is a reason for doing so, my lord. If I may take your lordship to the additional affidavit filed by me, the speaking order of the department itself says that they were searching the vacancy only with regard to 291 Rastavasha Vidya Mandir, whereas other vacancies were also available in the district. So this was the observation by this honorable court in the year 2018, that the order doesn't say that they should confine their vacancy, they should confine their requirements only within the district of Bongaigaon, or only within the school, that is 291 Rastavasha school.
No, so many things cannot be interpreted into these two orders. These two orders will have to be read for what it is there in the order. 95 order is examine, consider sympathetically. You're right that there is no restriction that it has to be considered within X post or Y post. But at the same time, there is no direction that you have to be considered against all the posts. We have to, if we restrict ourselves to the direction, it is, you will have to be considered. Not being considered, or you are considered and rejected, you come before the court, where after interference, the matter is again remanded back. This issue, perhaps that you ought to have been considered in giving you regular appointment. In the order dated 2018, in the recital of the order, there is nothing that your right will relate back to the date. It is only a question of
But since I was claiming my right since the year 1995, and it was the authorities, had they disposed of my petition or my application or rejected my application 25 years before, I would have come before this honorable court with a similar kind of order I would have received from this honorable court. Then my career would have been in a safer side. But now at this stage, my lord, it took 25 years. This is the vital aspect of this matter. The authorities took 25 years just to came to a conclusion that I am not eligible, I am not entitled to be regularized, as because
where is that writ petition of earlier writ petitions? Are they available in the pleadings?
Perhaps it is not in the pleadings, but perhaps the records were called for.
Records, I think. Or
Before that, if I may take your lordship to the speaking order passed by the secretary.
3997. 95 to 95. Yes, who's for the respondent? His claim, you see, if you come to this order of 3997 2016, order judgment dated 16/8. If you look into para 7, you read para 7. Do you have that order?
My lord.
It is running
16,
page.
16 order, my lord.
Yes, running page 38.
My lord. For the board, for both the reason as stated above, the order dated director of dated 10/3/2016 is found to be unsustainable, and accordingly the order hereby set aside as agreed by the parties, and in view of the entertainment of the petitioner as no indicated above, the commissioner and secretary of government of Assam in elementary department shall consider the claim keeping in mind the order of the order
So
dated
there are a few things here. Number one, besides the order of the director being set aside,
My lord.
is keeping in view the entitlement of the petitioner.
Right.
The petitioner's entitlement has been discussed. Number two is that both parties have agreed. This is the consent order. And number three, you will consider his claim. So, his claim vis-a-vis his entitlement will have to relate back from 95. 95, then 2016. If you look into the prayers of 95 and 2016, there is a claim for regularization. So, you are directed to pass an order keeping those entitlement and his claim. And this is a consent order. You have agreed. Now, what you have done is you have passed an order giving him appointment with effect from 2020. This doesn't appear to be in compliance with the order.
And we have also filed our affidavit.
Your affidavit does not throw any light.
No.
You will have to explain that part.
In running page 53, paragraph 5, my lord, we have stated that in compliance of order dated 2016.
No, it is not in compliance. How can it be in compliance? You go through the orders. If you have appointed him with on so and so, then it must relate back to his past services.
95.
95. That has not been done. You have not filed an appeal or review. And it is a consent order. So what do you want to do?
In this case, my lord, the petitioner earlier appointed as an honorary teacher, my ad hoc. And in that case, the Honorable High Court in Punima order judgment, my lord, only the stipendiary teacher will get the benefit of old pension, my lord. And some of the ad hoc teacher will file appeal before the division bench, which is pending, my lord.
Where is the government letter 2110-2020, page number 42? There's a reference of government letter 2110-2020. What is that? You are now working.
I am working.
How many years of service left?
4 years.
What are your grounds for challenge here?
The regularization, my lord, the effect of regularization and my area salary.
Area salary is
Yes.
once you are regularized. After
Once
you
I-
are regularized.
Yes, once I am regularized. Because all the year I had been working without any pay.
Yes, Mr. Nayak. Please come to the aid of the education department.
Lordship.
You examine it, we'll take it up on some other day. You see, there 95 there was an order
Lordship.
to consider sympathetically
Sympathetically,
if found to be working or something.
Eligible.
So no right was decided on that date.
Then subsequent judgment was there where the court correctly, rightly, wrongly had come to a finding that his entitlement has been decided in that order. And the matter was remanded back and it was a consent order that will examine his claim. So now his claim has been examined, but with effect from 2020 or 2021. So under these circumstances, he is come before the court that his original claim of being regularized.
No.
He is aggrieved not by regularization, not by arrear. He is aggrieved by the fact that he falls under the new pension rules. Had he been regularized, he would have come under the old pension rules.
But I think, Lordship, I have not gone through the petition.
You go through it.
So, but I think, Lordship, his date of appointment has not been challenged.
Date of appointment has?
Lord.
Has?
Subsequent, in terms of subsequent order, Lordship, an order was issued regularizing his service, Lordship. That date has not been. Lordship, as per the new pension scheme, Lordship, either you are in this side or that side. It is stated, that date is statutory, Lordship. 2005, February is statutory date. If you are this side, then you are new pension scheme, that side, whole pension.
That is why he has come. His claim is that I have to be regularized with effect from the day that.
No, that is not his, Lord, that cannot be, Lordship. Earlier order was only for consideration.
But that
No
is his
right
claim.
was decided that he has a right to be.
You
regular.
examine it. We'll take it
Lordship.
up on 7 or on 5th December. 5th December. For further hearing.
Lordship, item number 26, petitioner is here.
Yes, item 26.
Obliged.
Anything survives?
So in terms of the last order, my lord, the affidavit was prepared to be filed
What affidavit?
for clarifying the, my lord, response number 9, my lord, finance department. Lord, we produced the audit date 21/9/23.
We'll clarify your stand. What stand?
Lordship.
No, the stand regarding to
What
the, my
stand?
lord, applicability, my lord, because the petitioner is claiming, my lord, that he has not been granted one increment, my lord, when a promotion is granted, my lord, 2 increments are given. And 1 increment was not given to him. And as a result of that, my lord, anomalies in the pay scale have come. And my lord, subsequently, my lord, I am claiming the arrears and the enhancement in the pension amount. My lord, will see my prayer portion.
What is the stand in the affidavit?
My lord, affidavit was not filed, my lord.
So far as
Subsequently-
finance is concerned, Lordship, that affidavit has not yet been. On
Okay.
last date, direction was issued for
So you
obtaining.
file your
instruction.
affidavit.
Lordship, I'll file out. That
File
it is
your
awaited in fact.
Mr. P. Nayak, Leonard, Standing Council Finance, is permitted to, is given further time to file his affidavit as directed earlier by this court by the order dated 21/09/2023. Mr. H. Gupta appears for the petitioner list.
Lordship, I'm praying 3 weeks. Lord.
23rd January?
No.
23rd. Huh? At 2.
I am for LIC.
LIC. What is the issue here?
Issue here, my lord, the applicant was a branch head of the LIC branch office at Maligaon. This charge sheet was issued, disciplinary procedure was conducted, providing you every opportunity. Inquiry report has been submitted. He submitted representation agreement. Then penalty of dismissible service with recovery of 33 lakhs has been imposed upon him. It is in the year 2011 penalty order. He submitted an appeal and appellate authority rejected the appeal. Against that, both the dismissal order and appellate authority's order, he has approached this honorable.
What about counsel for you have a report. It does. All right, we'll pass it over for the day. None appears for the petitioner on second call. Mr. Counsel for LIC is present. Matter stands adjourned for the day. To be listed next week.
Smile. Okay.
Yes.
So in this case, actually, I'm report is not with me, my lord. So, my lord, I may pray one date, my lord.
Oh.
On
Record
7,
not available.
my lord.
You don't have the record.
Actually, my file is not with me, my lord. So, on 7, my lord.
All right. At the request of Mr. S.K. Mehdi, learned CGC.
And Standing Council AG,
Standing Council AG, Accountant General. Matter is deferred till 7 December. Mr. Talukdar appears for the petition.
One name of the Standing Council PWD and Finance also.
Names of all the standing councils, including Accountant General, PWD and Finance, were reflected in the cause list by the registrar. Yes.
That is a lordship. In this case, my lord, the first case is this, my lord.
Huh?
Initially, first of the case is this. Initially, I was appointed in 1988. Then subsequently, as junior engineer, subsequently, in 1991, there was a police case. I was arrested and I was suspended. Then, my lord, whatever, my lord, I tendered my resignation. That resignation was pending for 10 years. During the time, I was suffering from mental illness.
You did not attend?
No, I did not. In 2001, when I visited the office, I found my resignation is still pending. So what happened? I tender application, my lord, for withdrawal of my resignation. After that, my lord, they did not act, my lord, so we filed a requisition, my lord. During the pendency of the requisition, they have withdrawn my
Resignation.
resignation. So by withdrawing earlier requisition, I filed the second requisition, my lord, challenging that part, my lord.
Which part?
This part, my lord, your lordship, this annexure N will, this is the only document, my lord, this is the main, most stark document. Annexure N, page 42.
42.
42. Annexure N.
Yes.
Yeah, Lordship, got it. My lord, consistent upon the voluntary submission of resignation order dated 1/1/92 addressed to the chairman, managing director, NEPCO Limited, my lord, the criminal case disposed of and acquitted from the criminal charges later on by the honorable court in respect of Ayub Hussain, junior engineer, grade 1 civil. Chairman and managing director, NEPCO Shillong, has accorded approval towards acceptance of resignation letter 1192 tendered by Ayub Hussain Umrangtu with effect from so and so. Now, next two paragraph is very important, my lord, because that part has been satisfied by the honorable Guwahati High Court. I'll come to it. It is certified that there is no vigilance case, disciplinary case pending or contemplated during the service period of Muhammad Ayub Hussain, and accordingly, Ayub Hussain stands released from corporation with effect from so and so. Subsequently, my lord, suspension order dated 11/10/91, very important, my lord. Suspension order dated 11/1/91 in respect of Ayub Hussain is hereby revoked since criminal case of so and so, and he has been acquitted. That is, my lord, 27 February 2002, my lord. 2002, my lord, practically my suspension order has been revoked. So I approached the Honorable Guwahati High Court. Regarding that argument was mainly on acceptance, resignation, whether it is valid or not. And a relevant portion of the judgment, my lord, the judgment is page 45, WPC number 4919, and annexure P. I'll just go to relevant portion, my lord, page 55.
Yes.
Paragraph number 12 and 13. In my considered opinion, the concerned respondent acted arbitrarily, unfairly, and unjustly by issuing the impugn order regarding acceptance of resignation of the petitioner without considering the above withdrawn made before the said acceptance, as well as without giving opportunity of being heard to him after about 10 years of submission of his resignation letter. Paragraph 13. In the result, the impugn order dated 27/2/2002 issued by the senior manager so so far as relates to acceptance of resignation. Letter of the petitioner is hereby quashed, and no effect is to be given in respect of the matter. In the fact and circumstances, an appropriate consequential order will have to be issued by the concerned respondent in respect of the service of the petitioner in accordance with law. The question, if the petitioner is or not to be allowed to join in service, will have to be decided by the concerned respondent in accordance with law, and having regard to the facts and circumstances of the case, this petition is allowed to the extent stated above, disposed of no order. Now, whatever, my lord, here, my lord, I was allowed to join, my lord. In fact, I was allowed to join, my lord. Of course, they have considered, they could have rejected also. They have considered my case and they allowed me to join in my original post, my lord. That is my case, my lord.
Then?
I submitted my joining report, and your lordship will find, my lord, page 58, my lord. That is release, the subject release of subsidies allowance, which I prayed, my lord, and other consequential service benefit. And in continuation of our earlier letter referred to serial number 1, that is not here, and directed to convey the decision of the competent authority that the period of long gap of absence shall be treated as break in service, not unable to draw subsidies.
You are now working.
Now what? Now what?
You're working.
Yes.
So your only claim is that
Any
subsistence
benefit,
allowance.
subsistence allowance, my lord, that part, since I was under suspension from their record, it is now.
Well, who's for the NEPCO?
NEPCO rule, my lord, regarding subsistence allowance.
No, that's all right, but who's for the NEPCO? We'll have to find out someone. I think Mr. Senapati is there.
Yes, Senapati.
P.
Yes,
Senapati for NEPCO.
there.
Here in the office, it's Ahmed.
Oh, MZ Ahmed. MZ Ahmed.
Oh.
But now I think it is D.
Yes,
Senapati.
yes. Senapati wants
D.
it to-
Senapati.
A rule said that for
Standing Council NEPCO. NEEPCO. NEPCO. Yes.
no, madam, their rule said, but for subsistence allowance, I have to approach, my. So I did not approach. Well, that is there.
All right, we will hear it
Yes.
next week sometime.
I read it.
5 তারিখে কেটা? Total 6. We'll have it on 5th
My lord,
December.
my lord.
As the counsel for NEPCO is not present in court, matter stands deferred. Mr. A. Chaudhary appears for the petitioner list on 5th December. Mr. Dhar, you are appearing here? No. Please inform him.
My lord, my lord.